So we're gonna call you back on Thursday. They say that they have accepted you into the program, but they need to get a lower bunk. So we'll bring you back on Thursday and Norma will see if we can get the AGs here by Zoom.
Wonderful.
Okay.
You're good, Mom. Thank you. Honorable Judge.
Oh.
Stephanie Ward, Miss Hollywood.
You're so welcome. I really appreciate that. I'm so glad we were able to get that done. It took an act of Congress, though.
Good for you. I greatly appreciate your concern and you stepping in. You got them hopping over there at the jail too. The medical came right away and had me sign. You know, I was.
All right.
Thank you.
All right, you're welcome.
God bless you.
Oh, thank you. God bless you too.
See, Mr. Howie. Thank you.
Louis, you have one.
Yes.
Okay, just making sure I didn't.
No,
Desiree Castro.
That's what you.
That's you?
Yes.
All right, so on this one, Norma,
Yes,
can we recall this at the end of the month for you all to get your jury trial setting? We can't have a jury trial. We're currently in trial on another case.
July 30th.
And that would just be for you to get a date.
Okay, thank you.
All right, thank you. La Prentice County. Good afternoon. How's it going?
Going fine. There's two matters. One is even before you go on the record, one is a termination of probation. The probation officer is going to need some time to get some information from their officers. So we're just asking that we need to reset that.
All right, when do you want to recall it?
We can do it. She said she only need about a week, maybe a week or 10 days, whatever is at the convenience of the court.
All right, Ms. Ferguson, can I have a reset date for 10 days?
I can use July 10th.
That's fine.
July 17th?
That's fine.
All right, we'll bring you back on July 17th.
Yeah, there was another motion, Judge, motion for return of property. You had a case out of this court where the case was dismissed.
The state is in agreement with
In
it.
agreement,
so
Judge.
I will sign it.
Thank you, Judge. We appreciate it.
You're welcome. And if you will, if you need a copy of it, which I think you do. And that was in 3 different cases?
That's correct.
All right, state,
Yes, Judge.
that's the return of property in all 3 cases?
The motion that the state saw was specific to the impersonate public servant.
It's all the same property and
All right, if y'all will look this over and if y'all are in agreement to all of the cases, then I will sign it. And if you'll put agreed on there for me, please. Who's here on Robert Castillo? Yes.
We're on the trial docket today, Judge.
I'm sorry?
We're on the trial docket today.
Yes. So what I'm going to do is I'm going to recall you for the end of the month. We're currently in a jury trial, so I can't do 2 trials at the same time. Ms. Ferguson, when do you want to recall this?
July 31st.
And on that date, counsel, it will be for you to get a jury trial date.
Okay, Judge. I'll put them on here right now.
All right, thank you.
Thank you, Your Honor. Appreciate you.
You're welcome. William Jones. Anyone else? If you have not been called, it's because I don't have your paperwork. Let me know when they turn in the paperwork.
I'm doing the search right now.
All right, thank you. Court is calling. Court is calling 2024 CR 2651 State versus William Joseph Jones. Could I have parties announced?
Stephanie Pitlock with the state of Texas. Tony Hernandez, by half Mr. Jones.
And are you Mr. Jones?
Yes, ma'am.
Counsel, have you received all discovery? And did you review it with
Yes,
your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Jones, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Judge, we are not. We will be proceeding with count one, but we are waiving and abandoning the enhancement allegation.
Any objection?
No, Your Honor.
Mr. Jones, did you review the court admonishments and defendant's waivers and affidavit of admonitions with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 1 to 4 grams? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering into this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yeah, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. The state recommends community supervision. There is no application for deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Jason.
It is, Your Honor, with
Yeah.
one stipulation.
Yes.
We would like to ask the court appropriate time to probate part of its fund.
Okay. All right. Other than that, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Into the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's plea.
State offers State's Exhibit 1 and all attachments, Your Honor.
We have no objections, Your Honor.
All right, state, you may excuse.
Yes, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor, please.
Anything you wish to say on behalf of your client?
Your Honor, Mr. Jones is indigent at this time. He's been in jail for over 30 days. He does odd jobs and yards, landscape, that type of situation. We would ask the court to probate a portion of his fine. He also had a recent death in the family, Judge, so that's cost him some time away from home and from work, and of course, just being in jail.
All right, how often were you using?
Every day.
Okay. Do you have any children?
No, I don't, my wife does.
And what are their ages?
They're all out of the house. All of them are out of the house.
Are there any minors in the home?
No, no.
When's the last time you had full-time employment?
Full time,
Mm-hmm.
a year ago.
All right.
I've been doing this, I'm trying to get my own business going,
Okay.
doing lawns and trim trees and stuff.
All right, this is what the court is going to do. The court will sentence you to 6 years in the prison, suspended and probated for 6 years. There's a $2,000 fine that will be probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider with minors, regular reporting by Zoom or in person, regular random UAs, TAP evaluation and a referral to felony drug court in custody, 200 hours of community service restitution. I'm going to order the MRT. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 6 months. And there's to be no residing with minors. Probation, is there anything else? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney, okay?
Judge, for clarification, is the court sending him to felony drug court?
He's going to do a referral to felony drug court, and that's going to be done in custody. They'll probably be able to see you hopefully before this week is out. If not, they'll probably see you at the beginning of next week. Okay.
And depending upon that, it'll be.
Oh, then you will be transferred to felony drug court if they accept you. That's a very good program. So I'm hoping that you get accepted into that program, because if you were using every day, you have a pretty bad habit, and felony drug court will be able to take care of that, okay?
I think his question, Judge, is if he is accepted, does he get released at that point?
He will be transferred to felony drug court, and they'll make a decision on that.
Okay.
Because they'll be in charge of his treatment. They may say that he needs inpatient treatment. I don't know. If they say that he needs inpatient treatment, then they're going to give you inpatient treatment. Okay? All right. Thank you.
Thank you, Judge. Maybe excuse.
Yes. Christina Garcia.
All right, let's talk about that. This hearing had a little bit of everything. Patient explanations, a couple of procedural resets, and one rather poignant plea. Judge Boyd presided with her characteristic blend of composure and genuine care, maintaining a steady pace while managing a docket that bounced between logistical scheduling and serious sentencing. There were moments of levity, like when the defendant thanked everyone, complete with a cheerful "God bless you," but they never distracted from the gravity of the proceedings. The main event, if you will, was the case of William Joseph Jones, who entered a guilty plea for possession of a controlled substance. Mr. Jones appeared respectful and forthright throughout, answering the judge's questions clearly and acknowledging the extent of his use without excuses. He even shared that he'd been trying to start a landscaping business, which offered a small glimpse into the life behind the charges. His attorney advocated earnestly, noting Mr. Jones's indigence, time in custody, and a recent family loss, and asked that part of the fine be probated. The state handled the presentation of evidence efficiently, providing stipulations and attachments without any drama or contention. Judge Boyd methodically covered every required admonishment, making sure Mr. Jones understood the rights he was, waiving the consequences of the plea and the details of probation. Even when explaining the possibility of in-custody referral to felony drug court, she remained clear-eyed but encouraging, emphasizing that this program could be the help he needed to address daily use. The atmosphere in the courtroom was remarkably calm, almost businesslike, but not without moments of human connection, like when Judge Boyd expressed sincere hope that Mr. Jones would get accepted into treatment. That small exchange said a lot about her approach, firm accountability paired with a willingness to see the person beyond the case file. Overall, the hearing demonstrated a courtroom functioning as it should, orderly, fair, and transparent. No one appeared unprepared or adversarial. Even when discussing serious consequences, everyone treated Mr. Jones with courtesy. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one,